Hello everybody, today we are going to be talking about clinical trial related inventions, medical indication inventions particularly. I will be focusing on the EPO context, which will take about the first half of the talk, and then I will hand over to Anna to talk about similar sort of issues on a global level, looking at some of the major jurisdictions. We will try to sort of draw all of that together with some practice points at the end, and there will also be time for some questions. So first of all, looking to EPO practice, we have 30 years worth of case law from the Boards of Appeal and some quite well developed lines of practice when dealing with medical inventions. What I will try to do is pick out some of the key decisions and also some recent decisions in this area, which might give us a pointer towards the direction of travel at the EPO and the way that the Boards of Appeal are thinking about some of these issues. So, the first question, I guess, is, why are we concerned with this? Well, in patenting, there is always a balance between collecting the evidence that you need to support your invention, which tends to favour filing your application at a later stage in development, versus minimising the amount of disclosure that there is in the state of the art, which might point to your invention being not new or being obvious, which favours early filing. And it's a particular issue for medical inventions where there's a strong imperative to publish at least the protocols for clinical trials, and often details are also publicised early to raise funding, for example. And they are very, very expensive. It's a very expensive thing to do. And from a patent perspective, from a strategy perspective, we need to understand how the various disclosures along the timeline of clinical trials particularly can affect patentability for different sorts of medical inventions. And I'm going to look briefly under three headings: novelty, sufficiency, and inventive step. Before I do that, a quick introduction on medical inventions at the EPO. Many of you will know this. The claims are written in a particular format: active agent for use in treating a particular condition. It is possible to characterize the condition by particular dosages, regimens, patient populations, other aspects of the administration profile or disease state. The early case law, so from sort of about 15 years ago and earlier, was directed to claims in the Swiss style format, which is a slightly different format, but is still applicable to claims that you find now. And these issues are particularly relevant where there is already a disclosure in the prior art about an intended trial or a trial protocol. And we're going to be focusing particularly on that situation because that is one of the sort of major points at which there is a strategic question: do you file before or after going public with an intention to carry out a trial, or indeed lodging the trial protocol on one of the websites. There's a recent decision here published in March of this year that I think summarizes quite nicely the fact that a patent claim is inevitably a generalization of some particular embodiment. It might be a particular trial or a preclinical trial, for example, that inherently includes an aspect of speculation. And the Boards of Appeal know this, and they try to balance the need for patent protection without having evidence of every single conceivable treatment within the scope of a generalized claim. And I think what's interesting here is this focus on avoiding patent protection based on unreasonable speculation and on the basis of propositions that are prima facie implausible. And this question of plausibility or credibility based on an application as filed comes out quite strongly in sufficiency and inventive step case law, but is also relevant to novelty, as we'll see. And the difficulties in this particular area have been acknowledged by the EPO and have been acknowledged for a long time. This balance between the length of time and the cost of carrying out clinical trials and the need for patent protection versus having the evidence that you are not simply making speculation or implausible statements. And this T decision I've mentioned there is a very well cited decision. And it states that, you know, there are intrinsic difficulties here, and so we don't require absolute proof that the compound is approved before it may be claimed. And this, I think, recognizes the tension, the particular tension in this field. So moving straight on to novelty, under EPO practice, the question is in this particular scenario where you have an earlier disclosure of the clinical trial protocol, what is disclosed by that? Can you draw a conclusion about the actual existence of a therapeutic effect from that clinical trial protocol? And here, the EPO, some boards of appeal at least, look to the information content of that disclosure and ask the question, you know, is this a statement of intention? Is this something which is going to be performed, but without any real disclosure of an effect or of the expectation of a therapeutic effect? Or is it more than that? Does it actually rise to the level of being a statement of therapeutic efficacy itself? And if it does, the boards tend to look at a second stage, which is the enablement of that. And indeed, in some cases, they've spoken about the plausibility of the technical effect on the basis of a prior art disclosure. And we'll see that sort of mirrored in the approach to sufficiency for patents where the only evidence in the patent is a clinical trial protocol. And again, the boards have looked quite critically at plausibility in those circumstances. Just to give a quick example, combination medicament, 2 active agents, A plus B. The prior art discloses them individually for the claimed use, and it also describes an ongoing phase 2 clinical trial, but without results. And in this case, the board looked at the implicit disclosure of that clinical trial and asked the question, what would the person of skill in the art understand? And here they actually held that the prior art taught nothing about the safety of the combination and that an effective treatment needed acceptable safety as well as efficacy. And so they decided in this case that the claim to the combination treatment was novel in view of the prior art. But I think this highlights an interesting point, which is EPO practice is not black and white on novelty. You know, a prior art disclosure which doesn't have results, just because there are no results does not automatically mean that it cannot be an anticipation, that it cannot be relevant for novelty. It is more nuanced than that, and the boards of appeal do look in more detail at implicit disclosure and what the skilled person would understand, as well as considering the information content. Moving on to sufficiency of disclosure, general principles I think are summarized quite nicely in this decision that we saw a quote from earlier on. It's established and needs to be satisfied at the effective date of the patent. on the basis of the information within the patent together with the common general knowledge. And given that in a medical use claim, the therapeutic effect forms a functional technical feature of that claim, if the application does not disclose the suitability of the claimed active ingredient for use in that application, this is a problem of sufficiency of putting the invention into effect at all, and is considered under Article 83 of the EPC. This decision makes it clear that clinical trials or even preclinical experiments in animals are not always necessary, but you need more than just a simple verbal statement, in effect, believe me world, it works. And I think, we've probably all seen cases where, the supporting evidence is perhaps not much more than that. Typically, that sort of verbal statement is not enough. There needs to be something technical, verifiable, experimental, often, to the effect that the active ingredient does have an impact. Why is that important? This goes to the heart of this sort of plausibility question. It's not written into the legislation, but it is now well established in the case law that it's a threshold test, but that you need something in the patent which gives the skilled person that sense of it is credible or plausible that the technical effect actually occurs. And I've listed a couple of cases here, one where the patent application disclosed a clinical trial protocol, but that was not enough because there was nothing else in the patent that gave a theoretical or technical explanation as to why that would be expected to work. And in that case, it was held not to reach that threshold of plausibility, with the result that the patent was denied on the grounds of insufficiency. There's another case there where a patentee had argued that they themselves had the evidence and they stated in the patent that it worked. They should not have needed to include the evidence within the patent because, as a matter of fact, it did work and they knew that it worked. And the board rejected that argument and said that you have to disregard information which is not disclosed. The whole point about the patent is to disclose how to put the invention into practice. And this sort of hidden information is not good enough. And why is this particularly important? Well, if the effect is not made plausible, then the EPO will not allow you to rely on any later evidence, often the results of clinical trials that were ongoing but not actually completed when the application was filed. They will not allow you to rely on that positive result to support the fact that the invention does work if you don't have that plausibility satisfied from the application as originally filed. I've mentioned there that a case in which a single example of a non-working embodiment, this was from a later failed trial, this was a single antibody which was shown not to be therapeutically effective, was enough to deny the sufficiency of the entire claim, which was directed to antibodies, I think binding to the same antigen for that use. And the reason for that was because there was no evidence in the patent, no positive evidence to show that it did work. And so the amount of evidence required by the opponents in that case was relatively small because they were putting forward the only evidence of efficacy, which was obviously negative in that case. And actually that speaks to the third bullet point on this slide. Often the boards of appeal at the EPO have taken a general presumption that a patent is sufficient, but the strength of that presumption determines the weight of evidence that is needed to rebut it. And in that earlier case, The strength of the presumption was very weak because there was little or no evidence in the patent. And so the weight of evidence required then to overturn that presumption was relatively low, and a single embodiment that didn't work was held to be enough. Other factors that the EPO have taken into account, some recent cases there in the first bullet point from October, even a significant proportion of patients having a particular condition that do not respond is not a problem of sufficiency, as long as there is a relevant proportion which does benefit and there is an acceptable safety profile overall. So this is perhaps a slight departure from the general principle that the entire scope of the claim should be sufficient. Here it was held, it was not necessary to work in even the majority of patients having a particular condition. There's also, I think, a sort of general sense that the more well-known the active ingredient is, or the more similar the claimed medical indication is to known indications for that active or similar actives, the more likely or the easier it is to have sufficiency acknowledged. If it doesn't go against the prevailing opinion in the art, if there's no prejudice in the art, then sufficiency is much more likely to be acknowledged. And the level of evidence that you would need in order to support sufficiency is lower. And we'll see in the summary slide where we've tried to sort of give various levels of how well known the active was or how well established the medical indication was, to try and show, as you get further away from what the skilled person knows about, more evidence is then required in support. So, in summary on sufficiency, you don't typically need clinical trial data, but the amount of evidence that you need is very much sort of case specific. You depend on the nature of the indication, how well known the active is, what the skilled person's frame of mind is, is it a particularly difficult indication to treat or not? How successful have other agents been in treating that disease? There are lots of factors to take into account. And I think we'll see that in the sort of global perspective as well. There's a sort of sliding scale, and it's difficult to prescribe anything except to say that these things tend to be quite case specific. So moving on to Inventive Steps, the final section under EPO practice. This again is, the practice here is based on the principle that the extent of monopoly should be justified by the contribution to the art. Unlike sufficiency, which deals with the technical effect that is recited in the claim, the achieving efficacy for a particular condition, this now deals with technical effects that are not recited in the claim, but which a patentee asserts are a technical effect of the claim subject matter, such that they are built into the problem to be solved in the problem and solution approach. What is interesting is that there have been decisions from the boards of appeal, like with sufficiency, where you need plausibility in order to be able to demonstrate the existence of a technical effect, of a therapeutic effect, and to be able to bring in post-published data, where boards have only allowed patentees to make use of technical effects that are rendered plausible by the application as filed. And the T787 of 14 is an example of that. And this is, it's the same underlying principle. The board in that case said the verification of whether or not the claimed solution actually solves the problem, i.e. whether it actually provides the desired effect, must be based on the data in the application in order to avoid that an invention is based on knowledge available after the effective date only. So it's exactly the same sort of policy consideration, although I should add that this decision is not sort of universally followed. And as we saw before, the nature of the indication has a bearing on the skilled person's approach, and it's exactly the same under Inventive Step. There are two contrasting decisions here, one where the claimed active ingredient was known for a similar treatment. You'll appreciate the hurdle for sufficiency will be relatively low there, but in this case, 239 of 16, the Board of Appeal decided there was a prima facie expectation of success because it was a known active for a similar treatment, and so Inventive Step was denied. In contrast, in the second decision mentioned there, it was a medical indication where it was very difficult to predict the clinical relevance on the basis of in vivo models. And so there the board decided that although it would have been obvious to carry out the modeling, that would not have given the skilled person the expectation of success in moving into a clinical response in humans. So in that second case, Inventive Step was acknowledged. To give you an idea of sort of, which side of the line, I suppose, those two cases are on. As an example, this T 2015 of 20 from earlier this year, it was a known drug for treating asthma, although it was known in the art for treating a related condition, COPD. The claim was a dosage regimen. It had a very specific dose for inhalation for this particular active in the claim. And the board held that the prior art actually talked towards lower dosages for COPD, or a very broad range that was being trialed. And so they decided it was not the obvious result of routine experimentation to settle on the optimum dose. What's interesting here is that they bring absence of side effects in. And I think one point for me that comes out of the more recent decisions is the boards are looking at safety and side effects as well as efficacy when they're considering all of these grounds. And that may have perhaps an impact on filing strategy. So this is my attempt to sort of summarize where we are at. As I said, there's a sort of sliding scale here for medical indications between indications that are known through to, maybe new dosages, new patient groups, administration regimens, right through to new technical effects that you're relying on, which can underpin some of this, and then into completely new indications. So, getting further away from what's in the art, I suppose. And likewise with the active agent that you're trying to claim, it can either be known, maybe it could be a new formulation of a known agent, which is a little bit different. It could be an analog, which is now starting to get a little bit further removed still, or it could be a new active agent or a completely new class of agents. And based on what we've just seen, you'll appreciate that the point in time when you need to file your application, which is based on the evidence that you have available to you, is likely to change. And that's sort of summarized in this table as you move from known agents for known indications, which are probably going to lack novelty up at the top left, as you move down towards the bottom right, completely new classes of agents for sort of entirely different conditions. The amount of evidence that you are likely to require at the EPO is going to increase, down to potentially clinical data, right, for the that bottom right-hand corner. I've put "and safety" in brackets there with a question mark. As I said, there seems to be this sort of movement in the decisions of the boards towards considering safety and side effects as well as efficacy. And so I wonder whether that is something that needs to be built into the strategy and the evidence in the future. So, I think that would be a summary of where the EPO is at, the direction of travel. I think, acknowledging the difficulties in this particular area, and after some years of putting increasingly high sort of burdens on patentees for things like plausibility and additional tests that need to be required, I think some recent decisions show the boards doing what they can to acknowledge inventions, but they tend to need particular sets of circumstances to do that, and obviously the more comprehensive the data in the patent, the easier it tends to be for the boards to find in the patentee's favour. Although, of course, that's not always possible to do that because of the publication schedule of clinical trials, which is sort of where we're at. So with that, I shall hand over to Anna to take you on a quick trip through a more global picture of these issues.
So hello everyone, I hope that you can see on your screens now, she says, the slide deck are for my section of the presentation, and with thanks to Stephen for his sort of decisive and insightful run through where we stand in Europe in terms of plausibility and clinical trials. I now want to take a step back and give you a whistle-stop tour through some of the key jurisdictions, and look at those same considerations there, with the caveat that this is looking at these issues through the eyes of a European and UK patent attorney, and sort of our experiences, and sort of supplemented with some research into recent cases and commentaries in other jurisdictions. But obviously we are not acting as lawyers in those jurisdictions or providing advice, it's just a commentary. So with that in mind, I'd like to start with the UK position on plausibility. Just a summary really, because I think probably most of us are aware, and if you're not, this is a quick kind of refresher, that the Warner-Lambert and activist decision by the Supreme Court back in 2018 was really seen as raising the bar for plausibility in the UK. And the situation as it stands now is that in order for an invention to be plausible, based on the disclosure in the application as filed, you have to provide reasonable scientific grounds for a skilled person to expect that the invention will work as described. And those reasonable grounds or reasonable prospect does not have to be based on data in the application itself necessarily, but there does need to be a technical underpinning that is described in the application that can provide that prospect. As for clinical trials, I wanted to just flag a couple of cases which I think present some interesting similarities and differences in terms of how the UK deals with clinical trial disclosures. Now, in both cases, the patents in question were held to be novel over the relevant prior art, but obvious over it. So far, similarities, but there are some interesting, or at least one interesting difference I think that's worth exploring a little. So in the Hospira case, the first case, the prior art in question was actually a press release describing the forthcoming clinical trial that Hospira were going to carry out regarding the particular drug. So they were facing their own prior art, and it was relating to a trial that was going to be carried out. In the activist and ICOS decision from 2019, in that case, the prior art document was not a protocol, but rather an earlier patent publication from Actavis, from the patentee, which described the drug for the same indication, but not the protocol that was sort of related to the patented suit. However, the Supreme Court held that essentially there's this well-trodden path that clinical trials proceed down, and so with the knowledge of the patent that was in the prior art, and with the knowledge of the pathway through the clinical trial process, it would be obvious to try different doses. You would carry out a dose ranging study, and in the course of that study, you would it would be routine to arrive at a lower dose as was claimed in the patent in suit. And so for that reason, they found the claim lacked inventive step, even though there wasn't a protocol in the prior art per se. So what I'm going to try and do as I go through the different jurisdictions is just give you a visual guide to where I think the plausibility threshold and the risk from clinical trial disclosure lies, with green being on the low side, red being higher. And you can see that in the UK, we have a range. You know, for plausibility, you don't necessarily need clinical data or even data, but some sort of speculative statement is not going to do the job. For clinical trial risk, whilst it's unlikely you're going to face an objection of lack of novelty, there is a real risk of lack of inventive step objections being raised based on disclosures relating to clinical trials. And furthermore, it doesn't necessarily even need to be disclosure relating to a clinical trial itself, just a prior art disclosure that could be combined with that knowledge of the well-trodden path could be enough to raise an objection. So if we move on to Australia now, plausibility in Australia first reared its head, as far as I'm aware, in the Evolver decision back in 2017. And since then, the Australian Patent Office has looked to the UK jurisprudence to determine what the test for plausibility is. So in Evolver, that decision was based on the case law in the UK prior to Warner-Lambert. But since the Warner-Lambert decision was handed down, the Australian Patent Office has looked to and applied the tests set out in Warner-Lambert in multiple decisions, as a couple of which are on your screens now. And not surprisingly, given that they've turned to the Warner-Lambert decision, the plausibility threshold in Australia has increased. I think it's questionable, given the language that these decisions have used, whether it has increased to the same extent as it has in the UK, but certainly there is a creeping towards a higher threshold. So mere speculation alone is not enough. You have to have technical credibility. This is, I should point out, these are decisions from the Australian Patent Office rather than a test that has been sort of applied and tested at the Australian courts. In terms of clinical trial disclosures, you may be aware of a case that came out of Australia last year, the Mylan and Sun pharmaceutical case, where unlike in Europe, the European cases that Stephen has discussed, the difference between the sort of linguistic difference between describing a protocol as going to test something to see if something happens or not versus an expectation of a therapeutic effect didn't hold sway here. The full court decided basically that if the prior art described a protocol or a hypothesis, then that was enough to anticipate the claims in the patent in suit. And interestingly, in that decision as well, although it wasn't determinative because they'd already decided that the protocol disclosure anticipated the claim, there was also a suggestion that the double-blinded trial itself could potentially have anticipated those claims, even though obviously, as is standard in a double-blind trial, neither clinician nor participant knows what's being given at any time. So in terms of the ranges in the Australian practice as we understand it, the plausibility threshold is creeped up since Warner-Lambert, but is perhaps still on the low side, but the risk from clinical trial disclosures is much greater than it is in the UK, because obviously if you're talking about novelty rather than inventive step, you have very limited opportunity or arguments at your disposal to push back against those types of arguments. You can't argue there's sort of not expected effect. If the trial or if the disclosure is something that falls within the scope of your claims, then you're going to struggle. In terms of Canadian practice, Plausibility can also come into assessments of whether or not there is utility and you've met that requirement. And there was a test, a 3-point test that was set out in the Apotex decision. That test is there on your screen for you now. But basically, although the word plausibility isn't found in that test as set out, what it boils down to, I think, is that your disclosure in your application must not be speculative. And so the kind of the inference from that is, if you're not being speculative, then there must be a credible disclosure, i.e. a plausible disclosure. And in the issue of speculation and plausibility also comes into inventiveness, of course, as Stephen has discussed. But in this Canadian case, I was particularly interested. The question that the court asked, the federal court asked, is whether or not it was self-evident that what was being tried ought to work. And there was a sort of tension here between the data that was in the application, which was a limited clinical data, human data, but related to a limited subset of patients. And the court held that that data was not enough to soundly predict utility. But then in the prior art, there was animal data, and that animal data was deemed to be a starting point for attacks of obviousness. So, that's a really difficult position Pfizer found themselves in. That the court held that they acknowledged that they hadn't included all the data in their filing because they didn't want to wait for the results of the study before they filed and they secured their date. But that caused problems under utility, and then it was only animal data that was enough to start an obviousness attack. In terms of clinical trial protocol, unlike the situation in Australia, and perhaps more like the European and UK situation, there is jurisprudence which states that if you are carrying out experimental use, or there's a disclosure of experimental use, and that's in the context of clinical trials, that's not disclosure for the purposes of anticipation. However, it is relevant for, or can be relevant for, inventive step considerations. And in the TIVA and Pharmascience case that was handed down last year, I think it's interesting. It's as Stephen was saying, it's a complex, multifactorial situation that you have to consider, because in the TIVA and Pharmasciences case, there were 2 patents that were under consideration that I want to talk about. There was a patient subgroup patent and also a dosage regime patent. And in the first case, the multitude of factors included the fact that this was a trial for a drug that was known to treat MS, and it was being used in the protocol that was out there was for treating a precursor condition, and a large majority of those patients would go on to develop MS. And the court held that in that fact pattern, it would be self-evident to try, given that patients were going to progress and the drug that they were using was effective for treating MS. They did acknowledge that it wasn't self-evident that it would actually work, but that wasn't necessary to prove obviousness. All that was necessary is that the skilled person would think it was evident that you should give it a go. Whereas in the 802 patent, the situation was much more complicated, was entirely different. There were different doses in the prior art. It wasn't obvious that the doses interval that was claimed would be effective. There were other options that were available, and so Pharmascience had really had to try and mosaic the different disclosures together to arrive at an obviousness attack, and the court didn't buy that. They said in that case there was an inventive step. So you can see that 2 complicated situations based on the facts could give rise to different outcomes, and that I've tried to reflect in the ranges that I've put on the screen for you there. So if we turn to the US, the terminology is different, or in my experience is different in the US. You don't so much hear the word plausibility being bandied about. You think of written description in terms of possession of the invention, and enablement in terms of whether or not there was an undue burden to work the invention. But although the language is different, I think the same sort of considerations apply. And the question for a patentee or an applicant about when to file and how much data you need are very, very much the same. And again, it comes down to this tension between the predictability of the technology and the desired claim scope that you're trying to achieve, and the data that you're going to need to support that. So obviously, as unpredictability increases, so does the amount of data, and similarly for claim scope. So as for clinical trial disclosures in the US, I've got a few cases here. I wanted to start with this PTAB decision, just because as someone who acts for patentees, for the side of the patentee, I got a modicum of reassurance from the second bullet point here that it's not just prior to completion of a phase 2 trial that there's sort of room for manoeuvre, for arguing obviousness, but even up to evaluation of the phase 2 trial as well. So if you have to do something particularly clever to work out whether or not you've got efficacy, then maybe that's something you could hang an argument for obviousness or for non-obviousness over a prior clinical trial disclosure. But I then want to talk about briefly these two Federal Circuit decisions, which perhaps pour cold water on my hopes to a certain extent. In the Sanofi and Watson decision, again, as in many of these previous cases I've talked about, the prior art disclosure of a protocol but no data. In this decision, the Federal Circuit came down and decided that the disclosure of the hypothesis alone was not enough to establish obviousness. But in the decision, they state that the district court could have come down the other way. It was more a fact that the first instance court hadn't erred in their decision making. It was a matter of context as to whether or not a hypothesis gave an expectation of success, and the decision could have swung the other way. In OSI, again, the claims were found by the Federal Circuit to be inventive or non-obvious over the prior art disclosure in relation to OSI's own clinical trials, but that seemed to hinge, or at least on my reading, it relied upon the fact that a very large majority of trials for this particular lung cancer indication ultimately fail. And so the question is, well, if you were in a different fact pattern and perhaps only 70% of drug trials in that indication failed, would they have reached the same conclusion of non-obviousness? And again, I've just tried to reflect that in my graded bars for you there. So the last country I want to mention in any level of detail is South Korea. And I don't think any of us will be surprised if I say that they have a high threshold for plausibility, and that experimental data is typically required in the specification unless there is a sort of established pharmacological mechanism. And what I did want to flag is a case that came out last year wherein the patent court overturned an IPTAB decision and deemed that claims to a 4-drug combination for treating a particular breast cancer were both novel and inventive over a clinical trial protocol that was published on clinicaltrials.gov. So that's a positive finding for patentees, although I do question the drug in question here was a 4-drug combination, and the patent court seemed to place emphasis on considerations such as drug-drug interaction and whether a skilled person would have been able to predict there would be synergistic effect between the different drugs in the combination. So whether that combination, if there was only a 2-drug combination or a single drug that was being tested, whether you would still get that same determination of non-obviousness and novelty. So yes, so quite a difference here compared to some of the others where we've put ranges towards the middle. I think based on where things are in Korea now and that recent decision, the plausibility threshold, yes, is high, but potentially the risk from clinical trial disclosures is lower, with the caveat that obviously that was talking about a 4-drug combination, so there are facts, case-specific facts involved. China and Japan, generally, I think there's not been much in the way of change. They tend to have a high burden for sufficiency. What I did want to just flag it for those of you who aren't aware is that as of the start of this year in China, it's now permissible to submit post-file data to support your position on sufficiency and inventive step, provided that that technical effect is taught in the application. And so just to summarize that global section, what I've tried to do here is to give you obviously we've got the clinical trial pathway along the top, and then I've tried to indicate what we think might be the sweet spot for filing in the different jurisdictions based on those considerations of plausibility and clinical trial disclosure risk. And I think what the take home is that for each of them, there's no sort of one sweet spot. It's a range, and there's a lot of muddy brown colour at the edges where the facts are going to be really determinative. But also you can see that the green range is not the same for the different jurisdictions. Different jurisdictions take different approaches, and that will feed into your filing strategy depending on your key markets. So in terms of practice points, I think what we want to emphasize is that it all comes down to timing. You need to consider the timeline of the disclosures in relation to the invention that you are trying to claim, and understand from those the different time points for when the protocols and the results will be published and how those are described, and take into account with that timeline the specific facts around that invention in terms of the type of drug, the indication that you're treating, what was already known in the art about that active or group of actives, and try to reach a holistic view as to when is the right time to file for any particular indication or invention. And so if I may leave you before questions with our final thoughts, I think that the two main points are that the one thing that comes out both of the EPO case law and the case law that I've whistle-stopped through in the other jurisdictions is that finding a sweet spot will be very fact-specific on any given case. You need to consider the multifactorial nature of the case, the agents, the complexity of disease, and so on and so forth. And that will sort of lead you to a sort of filing window. But that it's, as well as that, it's not just enough to consider the technology, you also need to consider the jurisdictions, because the sweet spot may well vary between those as well. And so you need not only to think about the technology, but also the commercial drivers in key markets, and adapt your filing strategy as necessary so that you have the strongest possible position in the territories that are of most interest. And so, with apologies for running over slightly, I will stop there and I will open the floor to questions.
Brilliant. Thank you so much, Stephen and Anna, for that insightful presentation. We do have a couple of questions from attendees, and I'll just read them out. One question regarding China. Can you please elaborate on what it means for a technical effect to be taught for the purpose of making it possible to submit post-filing data? Is a prediction sufficient, or does it need to be substantiated with clinical reasoning or with experimental evidence?
I haven't been able to find a great deal of sort of commentary or case law when I was researching for this talk on this. Given my experience of Chinese practice, I would expect that a bold assertion is not going to be sufficient. I would expect that what you're looking at is some sort of technical rationale for that, and that whether or not a mere technical explanation is sufficient or whether data of some description is required will depend on the facts of that case. So, if you're working in a well-known area and you know that drugs of a particular class are useful for treating a particular disease, and there are examples of authorized successful drugs out there which do that, then probably you could argue that it would be enough that you have demonstrated that your drug is a member of that class, whether that's by chemical structure or some in vitro assay, and that's sufficient. Whereas if you are forging into an entirely new area, be it new indication or new class of actives, then probably you're going to need more in your specification in order to be able to then persuade the examiner that your post-file data should be taken into account.
Brilliant. Another question that we have here is, you talk about adapting the filing strategy. Could this involve filing multiple patent applications?
Yeah, I'll take that one. So I think in principle, yes. I think there are a number of issues to bear in mind if you're considering effectively filing multiple applications at different times, but directed to the same basic invention. Some would have more data, some would have less, depending on the point in time when you file. I think you need to bear in mind the typical publication window for a patent application. The earlier one with the less evidence in it, less data in it, will publish no later than 18 months after it is originally filed. So that automatically sets a window, I think, in which you need to be considering filing later applications for jurisdictions that would want to see more data in the application. There could potentially be some prior art effects of those in jurisdictions. I don't think you would want to enter them into the same jurisdiction. I think you'd need to keep them quite separate, or you could see an impact on priority entitlement or double patenting potentially. But I think there's the pros and cons of filing multiple applications like that. I suppose the pro is one of flexibility. You're trying to tailor the application to a particular jurisdiction, but there are definite cons in terms of complexities of the filing strategy, potentially for costs as well. So I think it would be very jurisdiction specific. It's probably quite case specific as well, but I can certainly see situations, particularly for important products, where filing multiple applications at different times could be a sensible strategy.
Brilliant. Thanks so much, Stephen. I think those are all the questions, and just in time because about running out of time. So thank you, and hope to see you at one of our future webinars. Thanks, everyone.